Aurora's case really launched, just a cascade of events right across the state. We saw other school districts, this whole concept of like a parental secrecy policy. I don't think anybody had even heard of before Aurora brought this case forward. So, with the decision that happened on Friday to basically revive the case, what comes next for her? Is she planning to, go back to square one with this, or how does that all work out?
Well, you're right that this really brought these types of secrecy policies to the forefront of the public eye. A lot of folks did not realize that schools across the state of California, including in Chico, were keeping the social transitioning of students secret from their parents. And I think a lot of people are rightly outraged when they found out about this. It sparked a lot of political discussion in Chico, and the school board debated this policy extensively and decided to keep it in place. And while we lost at the district court, the Court of Appeals has now vacated that dismissal and revived this case, like you said. So the next steps is, either to go back to the district court and, as the Court of Appeals directed it to do, reassess these parental rights arguments that it had previously dismissed, or potentially file a petition for en banc review at the Ninth Circuit. I mean, this parental rights argument was fully briefed. It was very well fleshed out before the Ninth Circuit, and the panel ducked the question and didn't actually answer it. So we're considering our options right now, what the best approach is. But the bottom line here is this is a win for parental rights. And if I were on the Chico Unified School Board, I would be very nervous right now.
So when you say considering options, I mean, is there any scenario where like Aurora decides not to move forward and not to continue like pursuing this lawsuit and because I mean I know that basically the ruling from before was vacated, but if she doesn't want to keep pushing forward, does that change anything?
We're certainly moving forward. She wants to
Okay.
move forward. What I mean by considering our options is, the constitutional question at issue in this case wasn't entirely resolved on this appeal. The Court of Appeals directed the lower court to revisit that question. We think it's unnecessary to go back down to the lower court. We think that the full Ninth Circuit, all 20 some judges, can weigh in and answer this question. And it should, because this is a national issue. This isn't just in California. This is in Massachusetts. This is in Florida. This is in Colorado. It's happening across the country, and there's been lawsuits filed across the country. And you had, in this case, in Aurora's case, you had just about every state attorney general in the country sign on to an amicus brief, either on one side or the other, advocating for the courts to resolve this question of whether parents have the constitutional right to be informed when their child is being socially transitioned at school. So the panel's decision not to address that question is very unfortunate. It's certainly a win because it vacated the lower court's dismissal. But this is a very important constitutional question that the full Ninth Circuit should address.
When we talk about it being, an important constitutional question, is it something that you could see going as far as the Supreme Court if need be?
100%. The Supreme Court's going to take one of these cases. Either it's going to be Aurora's case or one of these other cases that are percolating their way up the pipeline. And you saw, I think it was just a few months ago, Justice Alito had dissented in a denial of a cert petition in a similar case, saying, we as the Supreme Court need to answer this question. There are too many of these cases. This is too important of an issue for us to duck. So it's only a matter of time before the Supreme Court takes one of these cases. And given the makeup of the court, we're very confident that they're going to rule in Aurora's favor or in favor of the position that she's advocating for. So again, if I was on the Chico School Board, I'd be very nervous right now if they're going to continue to keep this policy in place.
Have we seen changes at the state level since she initially filed her lawsuit?
Yes, so
I feel like yeah.
there are several school districts across the state that have gone the other way from Chico and have actually mandated parental disclosure. And that prompted Rob Bonta, the California Attorney General, to sue these school districts under this absurd theory that there's this constitutional right to keep information private from your parents if you're a kid. That right doesn't exist. It's a made-up argument that Rob Bonta is peddling. And that has also prompted the California legislature to pass AB 1955, which, as a matter of state law, prohibits school districts from adopting these policies that require parental disclosure. But there's a carve out in that statute that says, unless federal law requires you to disclose this information. So, there are federal statutes that require schools to disclose educational records. FERPA is the federal law. And then also if the the Ninth Circuit or the Supreme Court answers this constitutional question, that parents have this constitutional right to be informed of this information, then that would also be, disclosable under AB 1955.
Okay. What is the soonest we could see more movement on this particular case?
We're going to decide in the next few weeks if we're going to file a petition for en banc review with the Ninth Circuit. So hopefully we'll know in the next few weeks whether that's going to happen or if we're going to just go back to the district court and present our arguments to the district court. So there should be some more movement in the next few weeks. And then, depending on which route we go, it could be, several years before there's a resolution, or it could be as soon as, 8, 9, 10 months. And so that's all part of the calculus that we're weighing right now.
And then just a reminder, what is she hoping to get out of this? Like, what would a win mean for her?
She wants the school district's policy to either be struck down or for the school district to revoke it, to rescind it. And so the school district can stop wasting everyone's time and taxpayer dollars and rescind this policy now. It's unconstitutional as we see it, and it would make sense for the school board to revoke it. But the school district up to this point has demonstrated zero interest in getting rid of this absurd policy. So we're ready to litigate it as long as necessary. But it is important to note that this isn't a case where Aurora is seeking a bunch of money. She just wants the policy to stop.
Okay. Is she seeking any money, any damages?
There's not a damages claim right now, no.
Okay. Like not even reimbursement of attorney's fees or anything like that?
That is a part of it, but that's separate from damages. There's a statute that allows you to recover your costs and attorney's fees if you end up prevailing on a constitutional claim, even if you don't assert a damages claim.